Committee. My name is Alan Snell. I'm a member of the Select Board, currently the chair. I'd like to introduce the rest of the members of our Select Board: Chris Robertson, Charlie Green, Alan Elkin, and Mike Curtis. I have a few introductory statements. I'll be reading to describe why we're here and what will be taking place. I want to thank you all for coming. Tonight's public hearing on 3 referendum questions that will be voted on at the polls as a secret ballot vote on December 11th between the hours of 7 a.m. and 7 p.m. at the town office. Then, this public hearing is being held pursuant to Title 30A of the Maine Revised Statutes under Section 2528 and subsection 5 of Section 2528, and then Sections 2.8 and 2.10 of the Orrington Town Charter. Specifically, under Section 2528(5), the Select Board, as the municipal officers, must hold a public hearing on the subject of the article at least 10 days before the date for voting on the article. The public hearing must be held in a manner that solicits and allows for discussion on the merits of the articles. Similarly, under Section 210 of the Orrington Charter, all persons tonight that are interested in the ordinance shall have a reasonable opportunity to be heard. At least 7 days before the date set for the hearing, the town gave notice of the public hearing by having a copy of the proposed article together with the time and place of hearing posted in the same manner required for posting a warrant for a town meeting under Section 2523, specifically by posting both the town office and the post office and at the library. The municipal officers have made a return on the original notice stating the manner of notice and the time it was given. Because the warrant for the December 11th town meeting, the polls with voting by secret ballot contains only articles for the election of the moderator and one or more referendum questions that are not tied to budget or finances. The municipal officers have specified the same voting place as that used by the town for federal, state, or county elections, specifically by voting at the polls at the town office. Section 3. Under Section 208 of the town charter, the circulators of the petition shall constitute a presentation committee, and they shall be responsible for explaining to the townspeople the need for action on the item in question. Thereafter, consistent with the charter and state laws, we will hear presentations by the town manager on Article 6, recommended by the Select Board, and the town attorney as to the review and formation of Article 4, recommended by the Select Board, in response to the board's review of Article 4, Option A from the petitioners, and 5, Option B presented by the petitioners. Let's proceed to hear now from Mr. Randall and the petitioner's presentation committee, and then I will call upon the town manager, Chris Bachman, and town attorney, Andrew Hamilton, to speak. And then once all presentations are completed, we will entertain comments and questions from the public on each and all of the presentations. I'll remind the public at the end of this public hearing by unanimous action that the Select Board have recommended on Article 4, 5, and 6. And now we'll go to Mr.
Randall, it's okay. How are you, Alan? Can you hear me okay? Yeah, okay. Good evening, and thank you for giving me the opportunity to discuss a few ordinances that are up for election, which takes place on December 11th, I believe it is, right, at the town hall? So I know a lot of you, but for those that you don't, my name is Michael Randall, and I've been a resident of the town of Orrington for 17 years. I am a husband, a father, a volunteer, a coach, a chaperone, a board member, a committee chair, and I have a child that attends this school right here. Together, with an abundance of help from Teresa Littlejohn and Renee Steller, and a petition to introduce the registered sex offenders restriction into the ordinance of the town was executed by members of our community. Some folks would ask, what business do citizens have to bring a petition for an ordinance into place? We did so because we had to, and it's the right thing to do for the town. The majority of the select board, not everyone, and the town manager have failed us. We asked for their help with this town-wide bipartisan issue. On a number of occasions, it was conveyed that drafting an ordinance was not an easy thing and something that they were willing to do. In addition, it was publicly recorded that the specific issue was not a town-wide issue and that it was just an Arctic Station Road issue. The state of Maine laws are very clear around what can and cannot be done regarding sex offenders living in any municipality. With that said, within the law, there's a provision. The state permits the municipalities to include distance restrictions from where sex offenders can live relative to where children congregate. I think we can all agree that if there are any protective measures that we can offer as a town, our kids deserve that. As it stands today, a sex offender can move right next door to this school. There's no ordinance in place to that end. If and when we adopt an ordinance, they'll be unable to reside within 750 feet. That's the maximum distance that the state permits. The reason that there is a petition A and a petition B going is because petition B is essentially a cut and paste from what the state permits. The reason that we did that is because a member of the select board and the town manager noted that if a petition was provided to them and it was deemed invalid or unlawful, it would be denied. So we didn't want to present a petition to them only to be denied. So we gave them two options, knowing that one of them was directly from the state. So that brings us to Ordinance A, which is the one that I'm heavily kind of involved in and relying upon. Ordinance A is very closely aligned with what the city of Bangor has in place for their ordinance regarding what registered sex offenders can live and can't live. I changed the language from Ordinance A that read town versus city, sheriff versus police, and anything that was pertinent to Orrington versus the city of Bangor. That's what they use to govern their restrictions. The city of Bangor attorneys have a history with this specific topic. Their attorneys have enhanced the restrictions over time, which is based on their own personal experience in the city of Bangor. I feel that this ordinance is vastly superior, and it speaks directly from experience with a much broader lens, which is to our benefit. And I assume everyone has the ordinance. I hadn't planned on reading it unless everyone would like me to. Essentially, it's the two-pager. Do you feel that there's any benefit to me doing so? I hadn't planned on it. No? Okay. So with that, I understand questions are taking place at the end. I was going to welcome questions at that time. To that being said, though, questions in front of a group of people can be uncomfortable, I recognize. So you can catch me in the parking lot, on social media, call me, email me, whatever you like, and I'm happy to talk about what actually really led to this, because it's a much longer story than what I'm presenting here. But I really feel that option A is what we should kind of lean on as a town. Teresa or Renee, did I miss anything or skip over anything or? Okay. So with that being said, Mr. Snell, I'm done with my portion. I don't know if you, yeah.
I'm sorry, do you have a question, ma'am? I didn't hear. No, not a question. I heard a comment, I didn't know if you had a question.
Oh, no, I'll speak a little louder. I just said that I didn't want to speak for Renee, but for myself, that I might get asked if he missed anything, and I felt that he was very thorough and clear.
Okay.
Yeah.
Thank you. I just want to be sure.
Sure.
Now, town manager, Chris Bodley.
Well, thank you very much. To carry on from what Michael said about reading these ordinance, there's a handout here in front of you that has copies of all three ordinance, A, B, and C. There's also a copy of the state law and a sample ballot. We also, for those watching on TV, streaming, or watching this video after the fact, Orrington.org in the public notice. Down in the bottom, there is links to all three of these ordinances. So if you would like to read along tonight or any future time, that's where you can get copies of these ordinances. Just a brief history that led up to where we are today is what I would like to do. that the select board, through my office, was requested to adopt an ordinance regarding registered sex offenders and where they could live that the state allows. The select board declined to take that up for any further discussion because there was no proposed ordinance in front of the board. The charter provides a provision that if the select board fails to take up the request, that it allows the citizens to go and gather 50 signatures and present a petition to be voted on to the select board. And that is what we're here today. As Mr. Randall said, they got 2 separate petitions together, got the required signatures, and presented 2 petitions in front of this town. The select board, myself, the attorney, MMA, reviewed those petitions, did not deem them completely illegal, but maybe created some uncertainty going into the future. And so the select board, myself, and the town attorney researched surrounding towns and pulled together several different ordinances and came up with the proposed ordinance, which is option C. That's what we feel is the best marriage between what the state allows and what the town would like to propose. The petition ordinances A and B present a lot of uncertainty and ambiguousness as far as where people can live and when they can live. And that presents a problem for the town, creating a situation where the town could be in trouble with a lawsuit. And to avoid that lawsuit, we would like to adopt ordinance C that would avoid those ambiguous terms and definitions. As we all know, winning or losing a lawsuit is not the costly thing, it's defending a lawsuit. And in my capacity, I worked and presented this ordinance C to the select board to present to the town for adoption. And I'd like to turn it over to Attorney Hamilton to talk about the legal stuff.
So, thanks, Chris. Thank you, Chair Snell, members of the board. It's perhaps appropriate that having gotten here 5 minutes before the meeting started, there was one chair open between Mr. Randall and Mr. Backman. And I do find myself a little bit in the middle between the petitioners and the town, because it's my job to go right down the middle. It's not to favor the petitions. It's not to favor whatever the town manager wants. My interest is to represent the town overall. And I think actually Mr. Randall and the petitioners can commend themselves for getting this issue advanced. Because what you'll be voting on December 11th, and I just want to be really clear about this, because they are Articles 4, that's option A, Article 5, that's option B, and Article 6, that's option C. C is the form of ordinance that I helped to craft with the town manager. He worked with Maine Municipal. We worked with several municipal ordinances that we reviewed. And I'd have to agree with Mr. Randall. He endeavored to take from Bangor ordinance, which I'm familiar with because I've lived there since 1984. I became a bit of a student in this area, and I'll speak to that in a moment, because Title 30A, Section 3014 is the law. And what the legislature adopts and the governor accepts becomes the law of the land. The charter provided direction as to the procedure. Section 2528 that was recited by the board chair provided the procedure. But substantively, 3014 provides the law. And it's really clear. And you can't go outside the lines. we learn as early as those kindergarten years, you're not supposed to color outside the lines. Petition Form A and Petition Form B as ordinances don't drastically color outside the lines. My job as an attorney advising a select board when an idea is presented by petition is to determine one thing and one thing only. Is it unlawful? I commend the petitioners. They did not propose unlawful ordinances. They weren't so grossly unlawful that I could say that the voters are being presented with an illegal question. The law therefore says that if the select board can't determine it's illegal, they can still reject the petitions, but if they do, a notary public can call a town meeting and take it out of the hands of the select board. And then those residents who want the select board to have the opportunity to queue up a good recommendation for the residents of the town, that opportunity is lost. It's the notary public that calls the meeting and the petitioners committee that essentially brings their folks, and the other folks from the town can come, but it's their town meeting. I want to describe 3 steps in the sequence here. Step number 1 was, should there be a sexual offender registry ordinance? Answer, yes. The select board and the petitioners agree there should be an ordinance. Question number 2, should the select board advance that? It's difficult in the dynamic where we knew a petition was going to be presented. And as soon as the petition gets presented, if it doesn't present an unlawful question, the select board can't change the language of the petitioned ordinance. You vote it. It gets voted up or down. The voters decide whether that's a proper form of ordinance ultimately. I can give my recommendation to the select board. They can give their recommendation to you, but it's ultimately your call. That's step 2 that occurred. Step 3 is your charter is darn awfully clear in sections 2.8 and 2.10. And I commend to every resident of this town that you read a pretty darn good charter. Section 2.8 is very clear. Once a petition gets presented, it gets acted on. And so these petitioners presented the dynamic that got this question before the town. They should be commended for that. There's no hostility towards the petitioners. There is, however, desire to make sure the town does it right, because you've got a balancing of harms here. You've got the liberty interests, the life interests of somebody who's admittedly a registered sex offender. I'm going to tell you in a moment what the state says about that in terms of how you regulate that. On the other hand, you've got residents who are concerned that registered sex offenders not live within the immediate proximity of a school, a municipal or state public park, where the primary users of that park are children, or third, facilities leased by the state or municipality for parks and other areas where, again, the primary users are children. So the select board had to do a balancing, and the balancing that was recommended to the board by the town manager and the town attorney was to craft an alternative to options A and option B. Not surprisingly, we sometimes call it option C. In my opinion, C is for correct. You know, when a teacher marks a paper, it's either correct or incorrect. Option C is correct. Does it take a lot of the elements that are in options A and B? Yeah, almost all of them. There's one important difference between option A and B on the one hand, and I have highlighted copies of A and B, so you can see in my highlights where the point of difference is between A and B versus C. A and B propose that somebody who resides in the community before this ordinance is adopted is not subject to the 750-foot setback until they move or they leave the town, irrespective of whether they intend to return. Irrespective of whether they intend to return. One of the members of the select board, Member Robeson, served in the military. He said, if I left the jurisdiction and I had an intention to return, you can't affect my residency. That's the law. And so what I want to do is suggest that that's the only real difference between options A and B versus C. If you're going to affect the life and liberty interests of an individual, you should do it in a way that's constitutional and consistent with state law. And so here's what I'd say about where we are. Again, I'd commend Mr. Randall and all the petitioners for their efforts. They said they cut and pasted a state ordinance as option B. I looked high and low for a state form of ordinance. I couldn't find one. What I found was many municipalities in the state, Bangor, Lewiston, Waterville, Augusta, you can run the litany, you can run the alphabet. A number of them have adopted ordinances. The one thing I don't see them doing is saying, as soon as you leave the jurisdiction for a few days or a few months, you lose the protections of the law. I don't see that. And so I adopted a form of ordinance provision that defines the term residence and the term domicile. And I think the state law says this pretty well. It's a function of preemption and retroactivity. Preemption is the concept that where the state or federal government intends to occupy the field fully, and they don't want anybody else to say what are the rights and responsibilities of a group of people, they express that in their law. Retroactivity is the sense that even if somebody has lived there, you can take their rights away and apply your ordinance retroactively. There are places where state statute does allow ordinances to be applied retroactively, but not in this area. So I'm going to read you a couple of provisions of 3014. And if you have any questions about these, the purpose of this public hearing is so that people can get their questions asked, get them answered, and go on December 11th to be informed, and then vote once you're informed. So I'm going to just read from state laws to preemption. The state intends to occupy and preempt the entire field of legislation concerning the regulation of persons convicted of a sex offense in this state or in another jurisdiction. And then they say in the next sentence why they said that. A municipality may not adopt any ordinance or bylaw addressing persons who have been convicted of a sex offense that would impose on them restrictions or requirements not imposed on other persons who have not been convicted of a sex offense. You may disagree with that provision of state law if you want, but it is state law. A municipality can't adopt restrictions or regulations that are more strict than state law in this area, unless it fits the recipe. And you heard the town manager earlier say, the intention of the select board was to get it right, make sure it's correct, make sure it meets the recipe. So an ordinance, according to the state law, may restrict only residents. It can't affect notice. There was a desire on the part of the petitioners to give notice beyond what state law currently requires. You can't do that. The law specifically says it may not impose additional restrictions or requirements, including but not limited to registration and fees. The registration process and the notification under state law is what's provided for. Again, I think what's going on is the state legislature figured out, based upon testimony over many days, that this is a charged area. You can imagine if 435 units of municipal government got to do it their own way, that you could have very emotional reactions to this issue. And so they said, you can impose limits, but only in accord with this recipe. So the recipe is retroactivity. An ordinance may not restrict the residence of a person who lived within the 750-foot setback prior to the adoption or amendment of the ordinance. So if on December 11th you adopt the ordinance, and I, again, recommend to you, as the select board do, option C, which is Article 6, that will provide that as of the effective date of that ordinance, any new person entering Orrington as a registered sex offender is going to be subject to the 750-foot limit. That's why I say the petitioners largely accomplished their objective. The difference between the petitioner's form A and B versus C is they propose the following. I'm just going to read a very limited portion of the text of options A and B. Option A provides any sex offender actually residing within a restricted area on the effective date of this section is not subject to the restrictions contained in subsection D while that person continues to reside in that dwelling. Upon moving from such dwelling, the sex offender shall comply with the restrictions contained in subsection D. That's a very slight but important nuance. It means that if you were given protections under law, those protections only apply while you live in that same spot. And the moment you moved, even if you had an intention to return, you lose the protections of the law. That's one important distinction. There's other distinctions that speak to a time frame of 25 days, whereas many municipal ordinances, it's been my practice to use a 30-day period. The further provision is that there is a limitation on where the town can bring an action. The petitioner's form of ordinance uses district court. The ordinance prescribed by the select board proposes either district court or superior court. I can tell you that if you want injunctive relief, you better be in superior court. District court, you may be SOL in terms of being able to prosecute a request for injunctive relief. So we've pretty carefully scoured the state municipal ordinances that provide for protections. And we've largely agreed with the petitioners, except for these two instances. If you go beyond, if you color outside the lines, the state statute's going to preempt you, and you can't adopt any notice requirement, and you can't adopt a requirement that divests a registered sex offender of residency unless they express by action an intention not to return to their domicile or residence. That's the difference really between A and B versus C. So I'm going to just speak to retroactivity. The option A ordinance presented by petitioners is preempted by state law and presents issues under state law that we have highlighted in yellow. Again, I'm happy to provide copies of the yellow highlights of options A and B so you can see specifically where I see issues with option A and option B ordinances. But the select board has to send that to the voters unless it presents a patently illegal question to the voters. An example of a patently illegal question is, let's say that you have a requirement for taverners licenses, so that before you can dispense alcohol, you have to get a license. And let's assume further the town adopts an ordinance that says you can't serve black people at a bar. That's patently discriminatory. That would be struck by a court in a heartbeat. I would say to the select board, that presents an illegal question. Do not send that to the voters. But again, there's shades of gray in A and B. Doesn't totally offend the law, but it offends it sufficiently that when you compare it against what 3014 of Title 30A says, it goes too far. It's preempted. Same with option B. The option B ordinance presented by petitioners is also preempted by state law and presents issues under state law that we've highlighted in yellow. But the select board has to send that to the voters unless it presents an illegal question. So the select board decided to send it to the voters as is. With the option C ordinance, which will be Article 6 on the secret ballot that you'll check on December 11th, we looked at many municipal ordinances across this state that follow the limitations of 3014. And even those that follow 3014, if it had the same provision that would divest somebody of their liberties and rights based upon moving, even though there's an intention to return to the domicile, we did not use that formulation. Instead, we selected from the best of each of those ordinances, choosing to make clear that prior residency or domicile would not be taken away by moving temporarily from the town if there's no intention to abandon residency or domicile in the town. But here's what we did. We used 3 tight exceptions and a general prohibition. You'll find in section 4A of the option C ordinance, a general prohibition that anybody moving into this community who's a registered sex offender cannot live within 750 feet of these three types of facilities: a public or private elementary, middle, or secondary school, a municipally owned or state-owned park, athletic field, or recreational facility that is open to the public where children are the primary users, or third, a municipally owned or state-owned property leased to a nonprofit organization for purposes of a park, athletic field, or recreational facility that is open to the public where children are the primary users. The law is clear in 3014, and it's there for the designated purpose of the statute. You may not like it, but the town has no choice. I'm sorry to say. You just don't have a choice in terms of whether you comply or not with a statute that says the legislature intends to occupy the field, and any ordinance that goes outside the permissive understanding in 3014, it's preempted. It'll be struck by a judge in a heartbeat. And there are civil rights organizations in the state, including the main chapter of the American Civil Liberties Union, that does bring cases against municipalities if they offend the line. In my opinion, as a licensed attorney in Maine for nearly 40 years, the option A and B ordinances presented by the petitioners committee, advanced to be Articles 4 and 5 for a vote on December 11th, are preempted by that law, 3014. Option C, recommended by the select board to voters, follows a careful approach to conformance with state law, and that ordinance is consistent with how the major municipalities in Maine established the residency restriction for registered sex offenders and will not be preempted by state law. So we protect the town with the option C ordinance in a way that won't be struck by a court. Would you rather have an ordinance adopted that could be struck by a court, feeling that it might protect you, or would you rather have one that does protect you and will be upheld by a court? I submit that option C is the correct approach to the issue, but Mr. Randall, I again want to thank you and commend you and the petitioners for bringing this issue forward, because it is a touchy subject. It's one that the select board didn't want to rush into, wanted to be careful and deliberate. And I think the platform, the foundation that was established by the two petitions, A and B, brought this forward and led to option C, which is pretty darn close to options A and B, but different in important ways. Thank you. I'm happy to address any questions.
Question of the lady.
Yes, ma'am.
Not specific to what you just talked about, but to the sample ballot. Why are we voting on each one yes or no? Why don't we just select one? Is part of my question. The other part is who decides and what is the legality of if question 3 is passed, it neutralizes question 1 and 2?
I'd like to repeat the question for the people that are online. And so your first part of the question was, why is there 3 petitions that we're voting on?
Why don't
Three-
we
three
just
articles.
select one out
I'll say
of
through
the three?
petition.
1 out of the 3. And the second part was, why does the third one, option C, if that gets voted in, preempts A and B?
Correct.
So we've created a little bit of potential confusion. I doubt that the clerk or deputy clerk in Orrington would ever confuse anyone. So I'm not going to suggest that. But questions 1, 2, and 3 are on the sample ballot. Articles 4, 5, and 6 are on the warrant. You've heard us address Articles 4, 5, and 6. The reason for that is Article 1 is to elect a moderator. That's not something that requires a sample ballot, a written ballot. Article 2 is to give the petitioners committee the chance to present, because the Orrington Charter says that if you have a vote by referendum, you have to give the petitioners the opportunity to present the day of the special town meeting. That will happen from 7 to 7:15. From 7:15 to 7:30 will be presentation by the town manager and town attorney on option C. So that's Articles 1, 2, and 3. Therefore, I do think it's very appropriate that they numbered questions 1, 2, and 3 just that way. But those are Articles 4, 5, and 6, just so there's no lack of clarity between the sample ballot that you have and the numbered articles. So 4, 5, and 6 on the warrant equate to questions 1, 2, and 3. It's pretty easy because we've used A, B, and C, and the petitioners actually provided a great deal of clarity by labeling their petition for ordinances as option A and option B, and the select board form of recommended ordinance is option C. A, B, and C equates to 1, 2, and 3. Your question is, why couldn't you have just put one on the ballot?
No.
No?
No.
Why can't you mark just one on the ballot?
Correct.
Okay.
So that,
You can bullet vote, as they sometimes call it in candidate elections. You can decide not to vote for 3, even though you've got 3 choices. You could vote for just the third one. Your further question is, who gets to decide why, if the voters adopt the third, it overtakes, it supersedes options A and B? Okay. So that second question is something we thought long and hard about, because when you get a petition, you have to honor the authority of the petitioners under the charter to present petitions. And again, state law is, if they present a valid petition that doesn't present a patently illegal question to the voters, the select board really has no choice unless they want a notary public to call the town meeting, because that's the remedy. It'll happen. So we've got 2 petitions, A and B. Agreed? So with A and B, if an alternative was to be presented to present a proper form of ordinance, that required a third article. The reason why we wanted to make it clear is because you could have a vote for A, B, and C to use the sample ballot 1, 2, and 3. And then which one do you apply? If everybody votes yes for 1, 2, and 3, let's just presume that scenario, or votes no uniformly for A, B, and C. The no is actually easier because it's always easier to negate the idea of adopting anything by voting no. If you vote no, it means you don't want A, B, or C. So let's go back to the positive. People vote yes for A, B, and C. If you do that, you're going to advance a dynamic where, although the select board presented what they think is a legally proper form of ordinance, you could have the same issue they're trying to get away from by presenting option C. And so I spoke with several attorneys in my office who have worked on municipal elections. I consulted with Secretary of State's office and I said, what do you do? They said, both in the warrant and in the ordinance make clear that an affirmative vote on Article 6, question 3, option C, would supersede any inconsistent vote on 1 or 2, A or B, or 4 or 5, warrant Article 4 or 5. So you have to make it clear, in other words, and you have to make it clear both in the warrant and in the ordinance. In both places, it's made clear. So it's presenting the town with the opportunity, I think, substantively to advance the work of the petitioners, but to say, if you care to get it right, your vote on C will supersede A and B. So let's take this scenario. Most voters decide we want to be magnanimous to the petitioners and to the select board. We'll vote for A, B, and C. It won't matter if you vote for C, that vote, if it's a vote that carries, will supersede the votes on A and B. Does that answer your question? Okay. Thank you for the question. I think there was another question. I'll defer to the chairman, sorry.
It is you, yes.
Looks like Mr. Stone.
I have very no knowledge about this subject matter, but everything that's been said is about registered sex offenders. And are there convicted sex offenders that haven't registered, or is the state registered when they're convicted? I guess my question, Andy, is should the ordinance say convicted sex offenders or registered sex offenders?
I'm going to repeat the question for those at home.
Good.
The question posed that the ordinance refers to registered sex offenders where there has been another class of convicted sex offenders. And does the ordinance cover or classify or, capture this class of convicted sex offenders versus registered sex offenders?
So, Jim, your question breaks open both a sociological and legal question. The sociological question is, there are sex offenders everywhere in this world. There are convicted sex offenders who are not registered sex offenders. There is protection given to communities only in the context of registered sex offenders. It really matters that you understand the answer to the question that Mr. Stoughton asked. It really matters, because society thinks that you're safe and you're protected from all sex offenders. That's not the case. You can have lots of people in your community who are sex offenders who are not convicted and therefore not registered. You'll never know. That's a sociological question. I'm not a sociologist, so I'm not going to spend more time on that. I'm a lawyer, so I'm going to address the legal question. The state statute says the following. Except as provided in this section, a municipality may not adopt or enforce any ordinance or bylaw addressing persons who have been convicted of a sex offense in this state or in another jurisdiction that would impose on them restrictions or requirements not imposed on other persons who have not been convicted of a sex offense in the state or another jurisdiction. As used in this section, convicted of a sex offense in this state or in another jurisdiction means a conviction for any current or former main crime listed in former Title 17, sections 2922 to 2924, or Title 17A, that's the current formulation of the Maine Criminal Code, Chapter 11 or 12, or Title 17A, Section 556. A conviction for an attempt or solicitation of those listed crimes, or any conviction for any former or current crime in any other jurisdiction in which the person engaged in substantially similar contact to that of the earlier specified current or former main crimes. It's basically a Class C or higher crime that is a sex offense crime, is what carries you into, if you're convicted, then a registration requirement will apply to you. And the state, through the penal system, sets the formula for how registry occurs and how notification to the communities occurs. Does that answer your question?
I think so.
It is a gnarly definition, but it's basically saying for the higher sex offense crimes, the ones that would, some people have used the phrase shock the conscience. It's those for which if you're convicted, there's a registration requirement. What we do in option C ordinance, which again is Article 6 or question 3, is we say the following: registered sex offender is an individual convicted of a crime against a person under the age of 14 years, and as a result is required to register pursuant to Title 34A, MRS, Chapter 15. Registered sex offender restricted residing areas is certain areas where there are significant concentration of children. And there are the 3 types of facilities that I described earlier. So we're tracking state law, specifically 3014, just the way it's written.
I have a follow-up question on that.
Sure. But I should say, Chairman.
Okay, Chair. who registers the sex offenders? In other words, we're referring to registered sex offenders in our proposed ordinance C. But if the state does it, fine. If the individual is supposed to register their.
No, individuals don't register. The state creates the registry.
Question up there, back, sir?
Yes, that's agreed. I'm not clear, are we gonna vote as articles, or are we voting a secret ballot as is shown here? The reason why I asked the question is if we're voting on articles, usually you present an article, discuss an article, and then vote on an article. And then you do the second one the same way, and the third one the same way. Is that how we're gonna be doing it at a town meeting, or are we going to vote by secret ballot after?
You want to repeat the question?
To repeat the question for those at home, to clarify how the vote is going to happen, there's been reference to Articles 4, 5, and 6. And on a usual town meeting, we present Article number 4, move second, discussion, and then we vote on it, and then so on and so forth. But the sample ballot is presenting the Articles 1, 2, and 3, A, B, and C. So how are we voting on December 11th for this?
So, and I'll accept help from the town clerk if she wants to provide it, because I think it's very clear, and I just want to take away any suggestion of confusion that I made earlier. I did it because I was thinking the same question that you're articulating, Mr. McCurdy. But I think it's very clear. Again, Articles 1, 2, and 3 are the following. Article 1 is to elect a moderator. That happens at secret ballot referendum elections. When you have candidate elections, it happens. You essentially elect a clerk, a deputy clerk, or a ballot clerk as moderator. And for the short period of the town meeting section, in this instance, it'll be the first half hour, 7 to 7:30. You're essentially moderating presentations and questions from the floor. Once the hour turns to 7:30, then the polls are open, and you're doing the same thing you do in candidate elections. You don't have presentations from the floor of town meeting. I think what the select board's trying to do here, and that's why they asked me about the secret ballot referendum process, is they're trying to get the strongest, most broad sample, the gathering of opinions of the entire community. Sometimes with a special town meeting, the only people that show up are the folks who presented the petition or the folks who have an interest in the question. This is A, emotionally charged. B, you want the whole community to get involved with this question and come and vote. And so it's being done by secret ballot. And you will use the ballot that will have questions 1, 2, and 3. And the language of those ballots, here's my question to the clerk to just confirm, and you can just say yes or no so that it can be heard over the microphone. Are we using the same text form of language in questions 1, 2, and 3 that we use in Articles 4, 5, and 6? Is the question the same? Okay. So the answer was yes. We're using the same text in the question substantively that we use in Articles 4, 5, and 6. I do think it's easier once you get beyond the presentations and the election of the moderator just to talk about, there's only 3 questions here: option A, option B, and option C forms of ordinance. And the most important thing, I think, is grab a copy that you can access from your browser of Title 30A of the Maine Revised Statutes, Section 3014. I happen to have 30 extra copies of it tonight if you want a copy of 3014. You should have that. You should know why we're doing what we're doing. And then number 2, grab a copy of option A ordinance, option B ordinance, and option C ordinance. And read those, because from this public hearing on November 30th until there's a half-hour total presentation on the morning of the 11th of December, you got lots of time to read. I'd read and inform. One thing I heard from a fellow voter at a statewide election, there were so many referendum questions on the state ballot this year. A lot of folks went into the voting booth and they really didn't understand what they were voting for because they didn't have the full text of the law that went with the question. It's different in Orrington. Orrington puts it up on the website. It's available to town office. You can get both and all forms of the ordinance, A, B, and C. And you can read those, and you can check me out as to what 3014 says by just accessing. It'll take you to the main legislature website. Just click on statutes and go to Title 30A, Section 3014. Is that clear, Mr. McCurdy?
Almost. You explained that all very well. The real main question I'm asking, are we voting on this by article, or are we voting secret ballot? And the reason why I asked the question is because if all of the arguments and things are gonna happen at separate times from when we're voting, that means we're gonna vote secret ballot all at the same time in the, or in a normal town meeting, where we handle Article 1, or Article 4, and then Article 5 and Article 6. When you do it in that format, each one of those articles is a separate issue, whereas on the secret ballot, it's all at the same time.
Okay. So way back in early October, the select board held a meeting, a regular meeting, maybe it was a special meeting, to determine how these questions would be acted on.
You explained all that really cool.
Yeah.
And I get that.
So 60 days notice is required. Once the select board adopts a warrant calling a special town meeting to be voted on at a secret ballot referendum, you have to do that 60 days in advance of the election. So all the voters of the town of Orrington, especially those that, pay attention to what happened at select board meetings, have known since early October, there's been 60 days, to know that on December 11th, the way this is being voted is by secret ballot referendum. There's a merger of the two processes that you talked about. Usually when you have a warrant, it has articles calling a special town meeting. Same thing here. There's a warrant out there calling a special town meeting to be voted on by secret ballot referendum on December 11th. So there's a merger between the two forms. You got a warrant with articles, but you've got a secret ballot process. And again, the reason they did that is the select board wanted the greatest cross-section possible of the opinions of voters in the community. And so they use the secret ballot referendum process. There will not be a town meeting format. That's why we're having the public hearing tonight. 2528 specifies that instead of the debate that happens on the day of special town meeting, you have it at a public hearing 10 days in advance. And we're also going to let the petitioners present again the morning of December 11th, because that's what the charter says you have to do. So there's a lot of process here, but it isn't confusing. It all comes down to how you cast your vote for question 1, question 2, or question 3.
You still almost answered my question.
Okay, go for it one more time. I'm sorry.
So when we go to vote, are we voting on all 3 at once, or are we voting on one, hearing argument on the other, voting on the second one? Are we voting on all 3 at the same time?
Yes, because there are 3 alternatives, but just as I was grateful for the gentle lady's question earlier this evening, I'm grateful for your question because I want to make clear and just bring this home. Question 1 is option A. I've already said there's issues there from a legal perspective. Question 2 is option B. I've already said there are slight legal issues from a lawyer's perspective. Option C, we drafted to take care of those legal issues with A and B, but to still give protection to schools, public parks, and facilities of that type leased to others, where the primary users are children. So you could mark your ballot, as the gentlelady asked. You could mark it for 1, 2, and 3. You could mark it for 1 and 2, but not 3. You could mark it for just 3. The vote that the select board is recommending, and the chair will come to it because the select board still has work to do once the public hearing is closed tonight. They're recommending to you that you check your ballot for question 3 and question 3 only.
I'm just gonna say one more thing, it's really not a question, it's not, all I'm gonna say is, I just wanted to make sure that there wasn't gonna be argument after we voted for the first 2 articles. That might change somebody's every one of these passes. And if there was gonna be somebody, able to argue on Article 6 at the end of the town meeting, after you've already voted for 1 and 2, I didn't want that to be able to happen. I see now, I think, that can't happen. So that was why I asked the question.
Right. So here's what I'm going to say, just to make it really clear. Most folks in this room are familiar with the difference between a rifle shot and a shotgun shot. A rifle shot is you aim and you hit one target. A shotgun shot is you're still aiming for one target, but there's a chance the shell, the material could strike another question. That's why it's called bullet voting. The recommendation of the select board is effectively to bullet vote for question 3, just to make that really clear. Because they're not recommending 1 or 2, and they are recommending 3.
So the question, yeah, I think your hand was next.
I think the clarifying point is from 7 a.m. to 7:30 a.m. on December 11th, there's a town meeting. And then after 7:30 a.m. till 7 p.m. is when people can walk in
That's correct.
and
That's correct.
vote one of these 3, or bullet vote, or choose not to vote, whatever.
Right.
So
That is
that
correct.
clarifies.
It's well said. Yep. Yep. Yeah, that's well said. I hope that's further helpful, Mr. McCurdy.
I think this lady has another question.
Yeah, if question 3, I'm just saying question 1, 2, 3, just for purposes of having this in
Sure.
front of me.
Sure.
Article 6, does not pass, and the other 2 do, which one takes effect?
So if 3 is effectively voted down by the community, we're in the world of hurt that the select board's trying to avoid.
But that didn't answer my
That
question.
wasn't the question.
Which
Go ahead.
one- Which one would go into effect if 3 was voted down and 1 and 2
Well-
are both voted yes, which takes effect?
So I think it's pretty clear that if 1 and 2 get the majority vote at town meeting, even though there's likely to be a challenge, that means that 1 and 2 will have to be sorted out as the new law in Orrington. There's a little bit of internal inconsistency between 1 and 2. 3 gets rid of the internal inconsistency and gets rid of the challenge factor.
Still didn't, I don't think, answer my question. So 3 is voted down.
Right.
1 is voted in, 2 is voted in. One of those 2 has to become.
One with the most votes.
No, what if it's a tie between 1 and 2? Again, I'm being careful to answer your question. I'm trying. But I think you've got an internal inconsistency between the law that comes out of the town meeting vote. So again, I'm trying to be as even-handed as I can be, but we're also trying to be clear,
I'm just trying to understand what
Yeah.
my vote means.
right?
So if it came down to 1 and 2.
Right.
The one with the most votes
Right.
is the one that would be. So in the course of 1, 2, and 3, is it also the one with the most votes? Because it sounds like if it's just voted in at all, it takes precedent.
So I'm going to point folks to section 2 of the option C ordinance, which was recommended by the select board. The second sentence answers your question on the other side of your question, and then I think it brings clarity to the way you frame the question. It says, if this form of this ordinance, the option C ordinance, is adopted in the affirmative by voters at the December 2023 referendum election, its adoption shall supersede the approval of any competing form of ordinance at the December 11, 2023 referendum election, including either or both of the option A and or option B petition forms of residency ordinance. So if the community is listening to what the select board are recommending, they're saying, let's not have an unclear vote in the community if at all possible. And the result will be is if you vote affirmatively for question 3, and that's the one that gets the votes, it takes care of the lack of clarity, the inconsistency, everything. If, however, in its judgment, the town meeting at secret ballot referendum decides we don't like question 3, we're going to vote it down, then what you're left with is, particularly if 1 and 2 pass, more than 50% of the voters pass the question, I think then you're going to have a further town meeting, because it's not going to be clear how you reconcile the differences between 1 and 2. So I'm trying to say this in a way that's not charged. I would hope that the voters would glean from this public hearing and from their own review of both the warrant and Ordinance C. That's the recommended path. If they don't want to take the recommended path and they want to throw this up into the air with questions 1 and 2, you're going to have another town meeting to sort out which is it, 1 or 2. Unless one particular form is so clearly ahead that it's the only one that gets more than a majority, in which case you still get the challenge question, but you probably don't have the internal inconsistency between the 2 ordinances. Is that helpful?
Yes.
Okay.
Thank you.
Yeah.
The gentleman on back on the left was next, and we have someone on the other side.
Jerry Perkins, retired educator, long time resident of Warrington. Been sitting here like everybody else for an hour listening. And here's what I understand that this is a very charged, difficult situation that we're voting on, that we're talking about. Here's my thoughts, just in a nutshell. All kinds of hypotheticals, we could go on for another hour. Here's my thoughts. We got the town manager, we've got a lawyer, we've got people that represent us up there that say, vote for C. That's what I got from it. And I think that, I would say move the question, but we're not voting. Thank you.
Okay, we have a question up back over here.
I echo what was just said, but to me, there's a few takeaways from this hearing. One, we had a group of people who had a particular interest in the subject, and well, all of a sudden, I get the microphone.
You're so elegant.
Yeah, I just want to say there's a few takeaways for me from the hearing. It's one that we're here because we had a group of people that had a particular interest because it closely affected, their area of residence initially. But I'm glad they took on this work. I'm glad they put the petitions forward. They got the signatures. They brought it to a point where the select board jumped in with their own particular option. I think it's important the town do what they can in this area. You're very limited to what you can do. The state makes it very clear, and Attorney Hamilton explained it very well. And I want to make sure that after the vote on the 11th, that we have an ordinance in place that provides as much protection as we can for the younger people in the community. That's the goal here, after all. And my takeaway is that the only way that we can do that and be confident that we're not going to be caught up in something that may or may not be defensible in a courtroom, and something that, if not done correctly, could end up costing the community much more than it already has. And a lot of effort has been put into getting option C in front of us. And I hope that we end up with a vote in the affirmative for option C. I'm not taking away anything from A and B. I know there was a lot of work put into it, but I trust Attorney Hamilton's recommendation. He's familiar with what we're dealing with. There's a lot of research that's been done. I want something in place on the 12th of December that can be defended without question in a courtroom and it won't entangle the town with a lot of legal expenses defending it from you just know in this day and age, there will be lawsuits if we adopt something that has a little bit of opportunity for challenge. We don't want to be in that place. And I hope that the petitioners would be agreeable to supporting option C. None of my business how they vote, but I'm just suggesting that if we want to do what you've been trying to do all along, and we want to do it the best way we can, I'm confident that C is the way to go.
Any other questions? Just one up to the left.
Andrew Maximic, I've been in Orrington for 45 years. I've been a public educator for 30. Just a couple thoughts on your sample ballot. If I'm a layperson, and I am, and I come and I pick up a ballot and I walk into a booth, I'm looking at it as, oh, question one is asking if I would like to have a sex offender notification policy. Right? That's what it says. And I say yes. Okay. And would I like to have a sex offender registry restriction? Yeah, I certainly would. Oh, would I also like to have a registered sex offender registry ordinance with the town? Yes, I certainly would. So I'm thinking all three of these are going to be passed. You know, why can't we just have what it really is? Do you want this person, or this person to be president? You pick one of them. Why does the ballot have to be so confusing? So to me, you know, pick one of the three choices. That's it. Not yes, no, yes, no, yes, no. And then, you know, the bottom passage of the town's proposal, you know, great. It supersedes the other two. You know, I'm fine with that. Unfortunately, we're here because it was brought to citizens' attention that there was no residency restriction on sex offenders. And I'm a little disappointed that when that was brought to the attention of our elected town officials, that they didn't say, holy moly, really? Maybe something should be done. So it was brought to the town and at a meeting, and Mr. Curtis said, you know, hey, let's act on this. Oh, no. And then Mr. Beckman said, I don't have time to do it and I won't do it. Well, guess what? You guys did it. And it could have been done, and we could be having a meeting right now just talking about let's pass C, because then we wouldn't have had petitions out there. And I believe petition 1 and 2, 4 and 5, or A and B, whatever you want to call them, were only done 2 because we were afraid that when we gave you 1, you'd say, no, doesn't pass. It has law issues. So we copied and pasted, or Michael did. He copied and pasted and said, you know, here, take one that other towns have done. And we thought tonight, I really thought tonight, we were just coming to talk about the one that the lawyer cleaned up and said, you know, this is it. You know, this is so confusing, and it's too bad that it didn't have to come to this. But here we are. And as you said, if 1 and 2 or A and B or 4 and 5 get passed, we're going to be in a world of hurt. So it's sad that it ended up being this way.
Do we have any more questions? I got one more in the back here.
Thank you, Susan Patton, and I'm always a day late and a dollar short getting to meetings, so I apologize, but it's also difficult with people's times and schedules. As you know, I respect all of you for serving, absolutely, and don't want to second guess what has already been done or said. I agree with this gentleman wholeheartedly in what he said, and it took me back a little bit to think that in today's day and age, that this hadn't been taken care of years ago. I don't know if we were ostriches with heads in the sand or not paying attention to the way the world is today, but the fact that the selectmen had to have people in the town petition them to do something about this is unusual to me, at least. So thank you for that. Thank you to the petitioners for bringing a cause that is so important. I was also shocked, and I don't know if it was a correct quote or not, so please forgive me, but to be told by a town administrator, for someone who is concerned about something happening in their community, that it is not a town problem, it's just a area problem, is incredibly insensitive. We are a town, we are a well-knit community that works together. I don't know all the background. I looked at that sample ballot and was confused as hell. And I had to joke that we made it as clear as mud in this. I agree, when you get into a state referendum situation, what's the number one chief concern with voters? The questions were written in such a confusing manner that we weren't sure whether it, what we were voting for or not. So I commend the petitioners for coming forward, to being citizens like that, that say that you have the right to petition your local government. You absolutely do have a right. I appreciate all of your legwork and your explanations, but I don't think having another town meeting is an absolute crisis. And my actual question is, just for educational purposes, you've talked about adopting some of these towns and communities and other areas that are dealing with this problem before Orrington did. What sort of challenges have there been? We're concerned, we're being told that we're going to be challenged, we're going to be challenged, we're going to be challenged. Okay, what have some of those challenges looked like? Is there standing in that regard? I'm just kind of curious.
So Ms. Patton, I'm familiar with your background, and I know that you have a lot of experience in covering public issues. And I'll say to you, there have been some assertions made in the last 5 minutes that I don't think are fair to either the town manager or the select board. And I just want to speak up as attorney for the town to say, you've got a dynamic here that most people in this room don't know more than about 30% of the entire issue. And we really can't talk about it. That's one of the challenges in this area. To go to your question directly, have there been challenges? Yes. The ACLU brings challenges across the United States, and the main chapter of the ACLU looks to protect rights and liberties. And they're pretty good at it. And you don't want to be the first community that creates the first precedent that they think goes over the line. I think just reading the state statute, the first paragraph of the state statute tells you everything you need to know. There's been a judgment by the legislature that this is an area where they want to be really careful with how rights and liberties are addressed. So all I'd say is I would be careful with the assumption that the town manager and the select board prevented any action on this. I think the better thing to understand is there was a lot of focus on one individual really early on, and there's a number of different ways you can get at that. And I guarantee you there's been a lot of time spent on one single individual because of the fact this is a charged issue. It always is. It is in every community. And sure.
So to that end, it was Ms. Patton, was it? Yeah, I'm sorry, I don't know you. Thank you for your comment. So to that end, I would remind folks that option A, it's clear and favored that folks would prefer option C as it was devised by attorney, but option A is one that was in Bangor. And I have to venture a guess that Bangor has been charged with this before, and Bangor has been successful through their efforts. Maybe, maybe not, I don't know. I don't live in Bangor, I can't speak to that. But to that end, they've modified that ordinance over time. So that's why I feel that A is a stronger option. But I empathize and understand. At the end of the day, we just need to get something to go forward because there's nothing in place. I feel as though A is a stronger option only because it's tried and true in larger cities. And to that end, option C is new. So I would almost argue that option A has been tested and used where option C has not, respectfully. So that's all I intend. And I do mean that with the utmost respect. That's all.
All I would say is that option A is a derivation, a change from most of the language that's in the Bangor ordinance. Option C is largely taken from Lewiston and Waterville. And I think those folks who know the state of Maine, the way I'm sure you all do, know that things get pushed and tested in the service center communities, like Portland, like Lewiston, like Bangor. I can tell you, it's this question of residence, domicile. If you move, you lose your rights. I think that's inconsistent with the Maine Constitution, the US Constitution, and I think it will result in a constitutional challenge. When and how, I could not predict with certainty, Susan, but I think it'll come. So I'll leave it there.
Another question on that?
Yes, just one more thing about speaking out, because talking about this is so important.
Okay. I just want to say that the reason why this meeting is happening is because people spoke out. And when we can't speak out, we can't solve any problems. And I know you thanked us for bringing this issue up. One of the reasons why we've had the little bit of pushback is we want you all to be able to speak out for us, because that's what you're here to do. And we want it legally. But sex offenders, domestic abuse, all those things are some of the worst crimes that we have to deal with. We cannot cower and not talk about them. So we need to know how to legally talk about them. And that's what we need you for. And that's what we need our select board and our town manager to do for us. And if not for these guys putting forward this petition because we were forced to do it, we wouldn't be doing that. We need to come back together as a family and be able to sit across the table from each other and talk about these issues. So we're legal, but we do everything we can to keep these events from happening. And just like the attorney said, there's sex offenders everywhere. This little law is not going to protect you any more than it did yesterday from the actual offenders. But it gives us a way to speak out and try and get this out in the open so that there's less of this in our world. And that's, so vote 1, 2, 3, vote 3, vote however we vote. Let's get this law on our books. And then let's not let this conversation stop, because we're still not going to be protected, as you said. We all need to know how to protect ourselves and be aware. And notification was one of the main reasons why when we find out that we can't get notification, we're still working on notification. And we're going to work on notification from here. So please, everybody, show up in numbers and vote this ordinance in, any of the 3, but if we end up with 3, that's great. It's legal, but that's not the end of it. And we still need to figure out how to be notified. And there is no angst from me to any of our people that are working for this town. And I love what you guys do 99% of the time. And this just tweaked the wrong way. And all we need to do is talk about it. That's all. That's all I'm going to say.
Any other questions? Oh, we got one more of that.
So first, it's confusing the 3 options the way as worded. My question is regarding question 3 as to why there is a change in the wording so as that it would not start off to introduce option or question 3 as to introduce sex offenders ordinance entitled ... Why did they change the introduction of option 3 to read so differently than the first 2 options to pose additional confusion?
So if there's responsibility for confusion in the text of question 3, it's right here. It's my responsibility. Let me just suggest that question 3 is pretty carefully worded to say, to see if the town shall adopt an ordinance entitled Registered Sex Offender Residency Ordinance as recommended by the select board. There's one important change. In the select board's form of proposed ordinance, there's a second change. On file at the town clerk's office, there's a third change. It's making clear to the voters You want something the select board's putting forward, look at question 3. The thing about representative form of democracy, particularly under the Warrington Charter, is people get to petition and voters get to decide. So the select board can't tell you how you have to decide. All they can do is give their recommendation. And they frankly rarely do that. But this is an area where, as Mr. McCurdy so eloquently said, you got to be able to have the discussion, but you got to have it the right way. So,
Yeah, I think you might be misunderstanding me.
okay, go ahead.
I have no issues whatsoever with the words ordinance entitled blah, 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 blah. The whole rest of this is fine. But when you read this, thinking of the people who are not here to understand the complexity, why we even have 3 things that sound similar, okay? You got the entire town who might show up to vote, and they're going to try to differentiate what's really different about the 3. And the first 2 start reading similarly, and it's very quick to point out where some differences are. The third one starts off completely different, and you got to really pay attention that, by the way, it's the most important one because it's recommended by the town. Whereas when you start to read this and you're not here and you read the words, only these words, to see if the town shall, sounds like, well, maybe. Okay, whereas the others are pretty quick to point out.
I see your point.
Okay.
So there's a quick answer to that question. The prescribed form of warrant articles and questions to voters in the state of Maine, particularly in municipal elections, is to see if the town shall. That's the prescribed form of question. The other forms of question actually don't conform with the way you're supposed to pose the question to voters. And it happens because you got to take the proposed form of petition and question that the petitioners give you. And you can't rewrite it. You can vote it down, but you can't rewrite it.
So my understanding is you can't change the wordings to questions 1 and 2. Is that correct?
Correct.
Is it possible to correct the wording to question 3?
How would you correct it?
I would say to introduce sex offenders ordinance entitled registered sex offender residency as recommended by the select town board. You know, just what you have, just get rid of to see if the town may be, shall, maybe will be. That's how it reads. Get rid of that. Just make it clear to introduce sex offenders residency ordinance and then complete the rest of it.
So if you walk into a voting booth at a state election, the form of the questions is to see if the voters shall.
We don't like any of those.
Okay, so
well, that's
it's
fine,
not,
that's
it's
fine.
not, it's
If you
not,
want-
it's
if you
not
wanna-
argument. My question is first, I will just take it in pieces and we'll leave it at this. My first question was, is it, you can't change 1 and 2, but is it possible to change the wording to question 3? I heard you say, yes, the wording to question 3 could be changed. Is that true?
No,
So you can't change the wording now to question 3 either?
no.
Okay.
People have already voted absentee on that, so.
Yeah.
Unless there are any more questions, I think we've had plenty of opportunity to share our thoughts.
Alan?
Yes.
I have a question.
Yes.
Are we locked into this ballot?
Yes. Yes.
I'm looking way down there. The way this is worded and the way this is laid out, Andy?
Yep.
Okay.
It's been posted.
It hasn't been posted yet. It's not.
The warrant has been posted, Chris. And absentees have been.
But I don't think we're going. I'm questioning that. I'm questioning the way it's laid out.
Signed back in October.
Yeah, but we never.
You better post it. Whatever.
You got an answer here.
I don't like it, but I got one.
I think we've had plenty of opportunity to hear your questions, your concerns. I appreciate that, and all of the select board certainly appreciates that. We do now, if there is any discussion among the select board, this is the appropriate time to have that now before we move on. You can comments they'd like to make?
My only comment is I am frankly disappointed in the way this is done. It is confusing. We're voting for three different things. I understand one of them offsets the other two or negates the other two, but you're still, I don't know. And so, but I'm a dumb concrete contractor, so I don't understand how this works, but that's, you know.
I would comment.
Yes, go ahead.
And as I look at the ballot, I understand things a little bit better myself. We have to word the questions in terms of the petitions just the way they were presented to us, which is why those first two might be a bit confusing. And on the third one, we're wording it to see if the town shall adopt and so on, which is the standard operating procedure for a warrant question. And that's why it's done that way. Is that a reasonable assumption?
Yes, it's also the way the Town of Warrington Charter prescribes that questions be put to voters.
Okay.
So if you think you're confused, you better change your charter.
Again, I think what Alan was.
That's fine.
Please, what Alan was saying was, and I kind of held back from saying it, that we were required by the charter to present the first two proposals because they were presented to us by the committee that developed them. And then we were advised, we being the select board, were advised that we needed to prepare something that would meet all of the legalities and the appropriate way to have it, so we had to present a third one. But by our charter, all three of those articles had to be presented. And that's why we're here tonight discussing the three. Because there are differences in them, is because they came from different sources. And now you will be asked on December 11th to vote on that. I would remind everyone that the select board did vote at a prior meeting to not support option A and option B, and therefore asked to have an option C developed, which we had done, and that's the one we recommended. So that's pretty much where the select board stands. Any other discussions? Then, if I'm sure the town manager of our attorney will advise me if I've spoken out of turn here or said something I shouldn't have. But I believe that now takes us to the conclusion of this meeting, of this hearing, I'm sorry. And the hearing will reopen on December 7th at 7 a.m. At which time goes first? I'm sorry.
December 11th.
What did I say? I'm sorry, December, I'm reading 11th, it said 7. You tell me a little nervous. December 11th, which is two lines like that, up and down. On December 11th, we will reconvene 7 a.m. at the town office, and the public hearing will be opened again. The representative of the petitioning group will be able to offer further argument, and our town manager will offer the argument. And then it will go on to the secret ballot voting, which is gentlemen up there. At that point, we'll be voting on the options A, B, or C in secret ballot. They're not A or B, it's C and D on the ballot, but they are choices A, B, and C as we discussed tonight. Any other questions? Yes, sir, that's one more.
7 a.m.
I'm sorry.
7 a.m.
That's the normal.
We're going to plead the fifth on that one.
We have a question here.
This is for the future.
What's going to happen? My next door neighbor is not here tonight. He's going to go in on the day of the voting, going to come to question 1 or A, B, whatever it is, and say yes. Then we'll go into the next one and say yes. One way to do that, I'm just saying, please learn as a select board, when you're setting these things up, it would have been nice to have one question, vote for one of these.
Yes.
This is one of the perils of democracy, when you have municipal government and you have a charter that prescribes exactly what happened. And I really want to bring the folks forward who said, it's too bad it could have happened differently. I watched this play out, and I have to say, I am not surprised at all. It's the usual way that it plays out. What happens is folks who really want to push an issue try it with the select board. If the select board says, we got lots of things on our plate, I think there's a facility called the Perk Plant that was occupying a lot of attention of this community. And they didn't feel that it was something that compelled that level of investment. Maybe they were wrong about that. But then the charter says what it says. And that is, once the petitions are presented, unless they present an illegal question, you got to put them before the voters. That's questions 1 and 2 on the sample ballot. Question 3 was an effort. Can we salvage this so that we can have something that probably the petitioners want and that everyone wants? And I think Andrew and Ed have been eloquent through the land use process and through this process in speaking up. And I'm grateful that you did. But I don't think you should blame the select board, the town staff, or anyone that it happened the way it happened. It's the usual way it happens. And I get the sense that folks think that the select board was insensitive to a group of people. That's not the case. And for those who don't love this format, it is what's prescribed by your charter. It is the natural consequence of what your charter says. And if you want to change it, change the charter. But just like legislation that's been adopted by the legislature and then not vetoed by the governor successfully becomes the law of the land. Your charter is the law of the land. If you want something different, then amend your charter. But I actually think the process worked. And I'm a little bit wondering why people think the process didn't work. It did work. People who had a real concern about this issue coming forward filed petitions. The select board responded by saying, if we're going to do this, let's do it right. And they put us to work. But every time a question gets presented, do you want to have a lawyer hired to spend lots of time on it? Not usually. That's not what I've observed with small Maine communities. And to answer the earlier question, there's a reason why service center communities address this question. Where do people generally end up if they don't otherwise have a home? They end up in the service center communities. So they have to have these protections in place. They have more parks, more schools. I'm really not surprised that it took this long for this to happen, but I'm sure glad the community has engaged the debate. And the thing I want to really make clear to everyone tonight is your community includes some people that really know how to speak up for themselves in a respectful way. They did it really well. And I don't think anybody has been deprived of a discussion or the opportunity to be heard. If anything, there's been more process. Could there be more clarity? Yes. But if you want more clarity, you probably want a little less democracy. And you probably want to change your charter. And I'm not sure that messy democracy is the worst thing. Sometimes efficient government that's dictatorial is a problem. And I've heard real balancing here towards messy democracy. And that's the usual norm in small town communities in Maine. So I just want to say, I think the petitioners did their work. I think the select board did its work. I think the town manager did his work. Most importantly, the town clerks, the town clerk and the deputy clerk did their work today, and they'll have to do it again on the 11th of December. And they'll cheerfully stay from 7 a.m. in the morning till 7 p.m. at night, because that's what they do. It'll work. Go vote.
Yes, one more.
Hi, Matt Littlejohn. I just want to make everybody aware that there's another sex offender that moved into town. Go check the registry out, find out who he is, what he's about, and just be aware, we have one more. Thank you.
Any other questions or comments? Then we'll ask for a vote to adjourn. Your motion? Moved by Chris, second.
I'll second.
Second by Alan. Any discussion? All in favor? The hearing is adjourned. Thank you.
I'd like to remind everybody. Yeah, I'm sorry, we're not.
You're adjourned, public hearing, but you've still got some work to do.
Yeah.